Hello everyone, I'm happy to be here and I would like to give big kudos to HQ MENA for organizing this event. Very well organization so far. I'm really proud to be part of this event. I will start by introducing myself. I'm a lawyer by profession. I'm a lawyer for more than 14 years now. Because I graduated more than a decade. And I'm in the crypto space since 2017, advising entrepreneurs who are interested in doing business in the crypto space. By background, I'm a finance and banking and M&A lawyer. This is how I started the law profession. Afterwards, I switched into the crypto space. And today, I'm also representing Ari10. Ari10 is a leading fintech company in Poland, and they are a global cryptocurrency exchange having products for B2B and B2C. They started their vision back in 2017, where they wanted to bring the traditional finance world into crypto space. And their vision and statement was very clear. It's crypto, simplified. This is the vision that drove them into doing business, and they accomplished that. Because today, they have tens of thousands of customers, and we are extending all over the places in Eastern Europe, Central Europe, and in Dubai as well. We are expecting to have a VARA license in a matter of few weeks. And today, because the European Union space is a very regulated space, I'm going to talk to you about how a non-EU company could do business in the European Union in a legal way. So I guess everyone knows by now about the markets in crypto assets regulation. I'll talk a little bit about this regulation. This regulation, it's the most comprehensive framework legislation at the European Union level right now. It was published on 9th of June 2023 in the official journal of the European Union. And this piece of legislation regulates crypto asset service providers, and other services related to crypto assets which are not already covered by the existing EU legislation. This regulation requires CASP, crypto assets service providers, CASP, to be authorized or registered in the European Union and to comply with a few rules like capital adequacy, conduct of business, corporate governance, protection of consumers, prevention of market abuse, and supervision. Also, this piece of legislation regulates how non-EU companies could do business in the European Union and when to rely on the particular exemptions that would allow them to operate without a license. And basically, ESMA, the European Securities and Markets Authority, is the delegated, empowered authority under MiCA to develop technical standards and guidelines specifying such a provision of this regulation. So basically, ESMA issued at the end of January 2024 a consultation paper on reverse solicitation under MiCA regulation, setting the stage for consistent regulatory practices in interpreting Article 61 of MiCA. Why Article 61? Because this article is of great importance in terms of non-EU companies who desire to do business with EU clients. Further, I want to dive into the reverse solicitation under MiCA. Basically, the reverse solicitation is not something that MiCA invented for the first time. Reverse solicitation is a concept which is common in the EU financial legislation. And the rule is like this. Broadly, if you are an investment firm looking to do investment activities or provide investment services to clients, you would need a license in order to do so. And this would apply even if this company is situated outside the jurisdiction where investment activities are to be conducted or investment services are to be provided. Basically, if you want to do it on a cross-border basis, you would need a license to do that. However, in some particular cases, it would allow a company situated outside that jurisdiction to do business with EU clients. But regulators are kind of keen to regulate this kind of activities because they do not want to create an unbalanced, uneven playing field, because one company from the inside of a jurisdiction would need to comply with the certain rules and regulation, and the other one would not to. So in order not to create an uneven, unbalanced playground field, the regulators would be keen to regulate each possibility. However, there is a few exemptions. Basically, today, the reverse solicitation exemptions, which we are talking about, is what would allow a non-EU company to provide services to EU clients. But now it comes to what is solicitation. What is solicitation in the European Union understanding? And ESMA, the delegated authority to provide draft guidelines on this concept, would state that this is to be rather understood as a prohibition to do business with EU clients, and the exemption is to be very restrictive, very narrow construed. Also, ESMA would state that when you say solicitation, what you need to understand by that, it's all kind of interaction, all kind of marketing, all of kind of promotion in as largest way possible, and also in a technologically neutral way. Solicitation refers to promotion, to advertisement or offer of crypto assets or activities to EU clients or prospective clients in any way. So without being like a limited list here, ESMA just provided some clear examples when solicitation would happen. For example, internet commercial, brochures, telephone calls, face-to-face meetings. If you are inviting a client to have a Zoom, perhaps. Press releases, any other form of physical or electronic social media platforms, mobile applications. If you are creating an event, organizing an event, a trade fair, perhaps affiliating with some celebrities or influencers, because this is the trend in the crypto space, right? And maybe you choose an influencer from the European Union. Would you solicit clients in the European Union? I would say so. Or maybe you are retargeting of advertising, or even like submitting a fill-in response, or doing a training or advertisement by way of a sponsorship. This would be understood as soliciting clients in the European Union. ESMA also stated that if you are having a website which is in a language not customarily English, but let's say Polish or Romanian, or maybe Hungarian, in the European Union, this will be a good indication that you are targeting clients from that particular jurisdiction. On the contrary, if you use a geo-blocking tool to prohibit a website being accessed by clients from this kind of jurisdiction, would also be a good indication that you are not soliciting clients in the European Union via your website. So pay a lot of attention of how you're doing business with clients from the European Union. And when you really can rely on the reverse solicitation exemption. Because any reliance on reverse solicitation exemption supposes that the client, at its own exclusive initiative, came to you. And I would like to emphasize a few things now. You know that reverse solicitation is not a concept invented under MiCA. It is under MiFID II, Marketing Financial Instruments Directive, in Article 42. It's the most well-known situation regarding reverse solicitation exemption. And after Brexit, ESMA disapproved the fact that investment firms continued to do business, saying that they relied on reverse solicitation exemptions, and basically the client came to them at their own initiative, when in reality the legal relationship started back a few years ago, perhaps. So they couldn't say in a very truthful way that the client came at its own initiative. So basically, each and every time you want to rely on this exemption, you'll have to analyze on the case-by-case basis if the client came to you at its own exclusive initiative. And please note that you cannot put that into an agreement, like a disclaimer, to put in front of the client, like he agrees that hereby he accepts the fact that he came to your website asking for a crypto asset services at its own initiative. Don't put that in a contract, don't put that as a disclaimer. So the reverse solicitation would apply for a limited period of time, and only if the same type of crypto assets are to be provided. ESMA stated which list of pairs of crypto assets would not be of the same time, of the same type. Utility tokens and asset reference tokens, electronic money tokens, referencing different official currencies, and crypto assets based on different technologies. So don't combine them, saying that after a while you promoted other type of crypto asset services or crypto assets, tokens, whatever, to a client just because a few weeks ago, he came on its own initiative to ask you a service. There are significant implications. For example, if you do not comply with the rules, enforcement action, and even the reputational risk, which is a huge risk nowadays, because reputation is currency. Some key takeaways. A reverse solicitation exemption removes the need for a non-EU company to be licensed to provide services in EU jurisdiction, where those services have been solicited at the exclusive initiative of the client. However, another key thing, if you are a company already operating, being licensed in the European Union, do not divert clients to other jurisdictions and put another company to act like an intermediate company, because you will trigger some implications for the well-being of your company. It's important to know that if the draft guidelines of ISMA will be implemented as such, it's kind of very minimal chances to rely on the exemption, on reverse solicitation exemptions. So you'll have to be compliant with the other rules and record the book in your bookkeepings each and every time a client really approaches you at its own exclusive initiative, in order to have a backup in case of any kind of, let's say, discussions with the authorities who would ask you questions as to how you conduct your business. So basically, this was my session today. My time is up. I would have liked to expand a little bit more, but I saw time's up for a minute now, so I was hurrying to finish up. If you have any questions, feel free to ask me, and I would like to address them during our breaks or later on. Thank you.